Hi, hello, how are you doing? Welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. If you're new here, this is Lawyers Info Hub. It's a great platform where we teach law, where we simplify law concepts for ease of understanding. I'm your host, Mercy, and it's always a pleasure whenever I'm here to share legal tips, legal knowledge, in the most simplified way possible. So today we're looking at tactics in negotiation. As a lawyer, as a law student, one of the things you'll be engaged in, or one of the things you'll be doing, or one of the things you'll be faced with in the course of your career, is negotiation. Negotiation for clients, you know, you can also be a certified negotiator, negotiation in place of transactions, in so many things. You'll be called in to negotiate, to mediate, you'll be called in to see how parties can settle. Even in our court rules, it's expedient that a lawyer tries to see ways parties can even reconcile their differences before coming to the court. The court should be the last resort. Now, you're not being taught many of these things in school, strict to sense so. Yeah. So you learn it, in the course of your work. And even though a lot of people have written texts on negotiation, styles of negotiation, what is negotiation, advantages of negotiation, tactics in negotiation. But I'm here to make it to simplify it for you so that I know it will help you boost your morale, give you insight on how to go about the next negotiation you'll be involved in. So sit back and relax as I explain some tactics you can use when you are involved in negotiation. Remember that whenever you want to go into negotiation, you must know what is in it for you in terms of your client. You must know what your client wants and the least they can take in terms of offers and what they cannot take. It's very important to know what your client wants so that in negotiation, you don't overreach your client and at the same time, you don't make you don't accept positions that will not be in the interest of your client. So one of the key tactics negotiators use during negotiation, and a lawyer can also use same as a negotiation in a transaction, is blackmail. Now, blackmail here in its use is most effective if the other party has something to lose, or if the other party has an interest they want to protect and they want to do everything possible to avoid a showdown. Now, if you're in that situation, for example, excuse me, for example, maybe in company proceedings in terms of trying winding up, and the company does not want the whole world to know that they're in bankruptcy or they cannot pay its debt. In that circumstance, they have a lot to lose. Or you've got your order to publish, sometimes many negotiators in that instance, when they're on a table of negotiation, they might use blackmail because the company has a lot to lose and they will not want the world to know what's going on. So when the other party has an interest to lose, they have something that they don't want the world to hear. They are protecting their interest. So blackmail is a tactic you can use and it's effective. Another tactics, negotiation tactics that you can use is what we call lack of authority. Now, where issues like are taken in limited form, where the negotiator is telling them there's a limit to which I can act. I do not have this authority to go beyond this. I do not have this authority to expand or to go above what our proposition is or what our position is. They make it look like, see, this is what I have authority to do, and I'm not in a position to expand the authority given to me. So this is the offer we have, and I cannot expand on this offer because I do not have the authority to do. So in that situation, it seems like this is the best they can only give, or this is the least they can do. So limited authority is a tactic negotiators use, is a ploy to get tentative agreement from the other side, to get an advantage under the gas, like under the guise that I do not have the power to do more. I do not have a power to go beyond this offer or this position that I have. So another good tactics a negotiator must know or that can be used in negotiation is what we call the behavioral tactics. Now, the behavioral tactics comes in different forms. It could be in form of outbursts of anger. It could be in form of boredom, lack of interest. You're even talking something serious. The person look like you like, are you done? Like, well, you have nothing to lose. You have to pay. You have to, people, show that expresses it. So sometimes they use that anger when they're so angry, they don't even want to calm down, their voices are raised, they want the whole place to be tensed so that you're doing all you can to persuade them, to let them to calm down. Like, it has not gotten to this, we're not fighting, you can't raise voices. People is a behavioral tactics just to stimulate or to make the person know, see, I can walk out of this meeting and nothing happens. You you know you are lost. So you did something, or they show this lack of interest in whatever you're saying. See, now you hold the yam, you hold the knife, that kind of attitude of whatever you want to do is for your own good. So you better take this offer, or you increase your offer. So when people show lack of interest in even what you're discussing, or they're just bored, nothing excites them in the meeting, they don't feel like I have nothing to lose. So it's a behavioral tactics people put out, to make you feel like they're doing you a favor, and it works. So when you are in that table of negotiation next time, people put up some behavioral attitude, know that they are trying to use the behavioral tactics to get what they want. Now, another thing is that the control of agenda tactics. Hey, agenda is meant to be mutually prepared. What is the agenda of the meeting? What is it that we're looking at? What is it that we want to achieve today? So if one party controls the agenda of the meeting, you know, the sequence, how things happen, where the venue, the issues to be discussed, the sequence of issues and all that, it has a way of giving them an upper hand. So both parties must ensure that they are in sync in deciding where is the venue of this meeting, or what is the time, what are the issues to be discussed. So it should not be hijacked by one party who is in control of the agenda, who says what, who gives the guidelines, the sequence. So when most times when people hijack the agenda of the meeting, it's not in the interest of the other party. So everything that should be done in that negotiation should be party mutually agreed by both parties. Now, I've talked about the limited authority tactics. There's also the lack of authority tactics. In the limited authority, the person is saying, I have authority up to this level. But the lack of authority tactics, the person is saying, the instructor is saying, I lack the authority to even, to reach a compromise. I don't even have that authority. They will make you know that I'm not even the person that can even give authority. I'm just here to talk on behalf of my client, but I'm not in that position to make demands, or I'm not in that position to even give some certain concession. They'll tell you, I'm not even the person. I lack the power. I can do anything. So this is what my clients want, or this is what we're presenting on the table. Is that you take it? I don't have the power. I'm not in the position to give you what you want. So in that instance, it makes the other person look at like, isn't it better I accept this thing? Why is this person talking like this? But even if he says he lacks the authority, by the time he gets back to comfort, this will take time. And especially if the other party is in a hurry to seal the deal or to just take whatever offer that is presented to them. So that lack of authority tactics, a lot of people, negotiators use it to manipulate the other party. Now we have the take it or leave it tactics. It's very important you define the interests of all parties from the beginning. Some negotiator will just employ this tactics of placing their bargain decisively before the other party without giving them room for back and forth deliberation. So it's about take it or you leave it. This is what we have to offer. We are not going further. We are not going back. We can't move forward. We can't move back. This is where we are. So it's either you take us from where we are or you leave it. So that take it or leave it, sometimes when people present it is when the other party has a weaker negotiation strength, and they don't know what to do. Like, is that we take this or we just leave it? Or we go back to court, or we just proceed from here. So why are so it's important to understand this tactics when it's being thrown out or when it is being used by the other party. So it's a take it or leave it tactics. You must master it. And This take it or leave it tactics works more when the other party has a lot to lose. Now we also have the psychological tactics. The psychological tactics here, the negotiator use the givings of psychology, emotions, moral appeals, to arouse the other party to for sympathy, flattery, the humor to disperse tension in order to avert a deadlock. Now, when a negotiator is seeing that this meeting is really a deadlock, he starts to use that psychological appeal, begin to use those appeals to make the person relax, to douse tension, so that the negotiation will not reach a dead end. So they can be extremely ridiculous or project this deceit of unworthiness. There's a way they just go about it. So be mindful of negotiators who try to use these psychological tactics, because most times it works. They come and appeal and appeal and appeal. That even if you're shouting, they're trying to calm you down, they're trying to see that party move forward, and all of that is a psychological tactics to get at you and to get what they want. It's also very important to note the package tactics. This package tactics, it's more like an exploitation of pigs. Is a piecemeal tactics, but exploitative in nature. When a negotiation insists that all issues be taken as a whole, you don't want those issues to be broken down. No, let's just take it as this. Let's just take it as one issue. Let's discuss it as one issue. What about this is an issue you need to break down? Maybe you're owing this. What are the interest? When are you paying? What are the installment? If you fail at the payment of the second installment, what is the interest? Is it going to increase? Is it going to decrease? No, they don't want all those details. They just want us. Let's agree. We are paying or we're not paying. Or this is what we have. They don't want those other small details that are to the benefit of the other party. So it's a package tactics. They don't want issues to be discussed in piecemeal, but rather they want to take it in whole. So you have to watch out. As a smart negotiator, you have to watch out. So the other tactics like the contextual manipulation, you know, where they may be in the venue is being manipulated to create an inconveniencing environment for the other party to quickly reach an agreement. Where the person says, okay, let's meet in a place that is not convenient for the other party. And because that place is not convenient, they're in a hurry to go, they're in a hurry to conclude things. So, is a contextual manipulation. They fix meetings in an unconducive environment that will make the other party hurry, to go. We have also have the threat tactics where there's a use of threats to compel the other party to concede. You know, so you have to be watchful to look at which tactics is this person using. With tactics. Now, the use of puffs. The use of puffs is in the view to mislead the other party into believing that, well, whatever agreement you reach will not impact on me, on my client negatively. It is you that is at fault. It is you that will bear the cross. It is you that will be exposed. It is you that will, fall into your business, will crumble. It is you. They call it puff. Like, I don't care. It is you that, that it affects more. So when people use those tactics, you must know where they are driving at and what exactly they are doing. Now we have the Nebo tactics, where after an agreement has been reached, a negotiator is now asking for further concessions. With the Nebo tactics, the intention is to get more concession with the other party to grant it gradually since an agreement has been reached. An agreement has been reached, and the other party is just trying to look for those specs like that might not even work in the interest of the other party. You have finished agreeing, and someone is now trying to say, okay, please, can we just remove the aspect of paying interest? I know we will pay, and I vouch for my client, they will pay, they will not. So let's just remove this taxes or remove the deadline for payment. Just say we're going to pay within 3 months. You don't need to put must pay on the second or must pay on the third. These are nibble tactics. We also have the deadline tactics. Yes, the deadline tactics, where time limit is attached to an agreement in order to pressurize the other party into granting concessions within the deadline. So you have to be careful when deadlines are being given in negotiation. If it's not what your client or the party you represent can give into, don't let them be pushed into that pressure, because it comes with a lot of pressure. The deadline tactics, it comes with lots and lots of what you know of pressure. So these various tactics I've mentioned a lot of them. I mentioned the threat tactics, I mentioned the puff tactics, the label tactics. We talked about the limited authority, lack of authority tactics. We talked about the blackmail. We talked about the behavioral tactics. We talked about the control of agenda tactics. We talked about the psychological, the package, the contextual manipulation tactics. We'll talk about the take it or even leave it tactics. There are so many other tactics you can utilize as a negotiator to get what you want on the table of negotiation. So, friends, you must master these tactics and also know so that when the other party is using it, where is this person driving at? Why is this person using these tactics? What is the end point? What do they intend to achieve in using these tactics? So it's very important so that in following through your negotiation, you will not be at the receiving end in terms of, the stakes are high for your client. So everything has to be mutual, and you must get what you deserve at the end of the day. So whichever side you are in, you must know these tactics. And when someone is using it on you, you know where they are driving at. I hope you learned something today. The idea of this channel is to help you as a lawyer, to help you as a law student to simplify law terms, law tips, concepts, topics to the most easiest form you can ever have it for ease of understanding, for ease of practicability, and for you to make it to become a better and an excellent lawyer at the end of the day. So if you have any questions, please drop them. We'll have several contents on our platform that are very beneficial to you. And if you're yet to subscribe to the channel, please do hope so you do so fast. Please just hit that subscribe button, join us so whenever we are live, you are notified and you can follow through the class. If you have any question on any topic we've treated, drop it in the comment section and we will respond to it. Thank you, and don't forget to do a thumbs up on the video if you enjoy it or you like our content. We really appreciate our returning subscribers. We are very grateful. Thank you for your consistency in following this channel and to ensure that we're always coming by to see what we have dropped or what is new on the channel. We really do appreciate it. Do take care of yourself.